Welcome to The Debate. Imagine a world where physically occupying a space for just 30 days grants you the exact same legal rights as the property owner. Or, conversely, imagine a world where dedicating years to mastering a subject means absolutely nothing without fulfilling a really rigid 6-semester physical residency requirement. Today, we examine who truly owns a space, both physically and intellectually.
Right. And before we unpack all the mechanics of property and possession today, we are asking everyone listening to please like, subscribe, and follow the show on whatever platform you're using right now. Your direct support is, well, it's the mechanism that allows us to keep building these deep analytical investigations.
Absolutely. And a very strict brief status update regarding the ongoing legal proceedings in Martin Stevens versus OpenAI. The parties have formally entered a voluntary quiet period. There has been no public settlement reached at this time, and the dead man switch has not been activated. We will continue to monitor the docket.
Right. So our central inquiry today really revolves around the frameworks we build to protect our institutions and our physical spaces. We're looking at a very specific question.
Yeah, we are.
Do rigid, codified frameworks, such as New York's highly controversial property and squatter laws, or even, Stern College's unyielding academic residency requirements, do they ultimately protect the integrity of a system? Or do they just inadvertently create loopholes that bad actors exploit, necessitating a more flexible, case-by-case approach?
Exactly. And to explore this, we are drawing directly from the Stern College for Women 2024 to 2026 academic catalog.
A fascinating document, really.
It is. We are looking specifically at its addendums on residency, majors, and the advanced Talmudic law courses. And we're placing that academic framework directly alongside the legal records of New York's adverse possession statutes, the Housing Stability and Tenant Protection Act of 2019, and the 2024 and 2025 anti-squatter amendments, specifically NY Bill S-2366.
Right.
I will be arguing that strict codified rules, whether requiring 128 credits and 6 semesters in residence for a BA, or New York's recent legislation completely stripping squatters of tenant rights, are absolutely essential. They protect systemic integrity and defend rightful owners.
And my position is going to be that overly rigid codification inevitably breeds exploitation by, professional actors. I'll argue that true justice requires the kind of substantive, nuanced analysis of context and intent that's actually taught in Stern's own advanced Talmudic studies.
Okay, so I want to start by just addressing this idea of space as a container of value. Whether we are talking about an academic institution or a residential property, society creates a container.
Sure. A framework.
Right, and we collectively agree on the strict rules for entering and benefiting from that container. When a society or an institution attempts to be overly accommodating, or when it relies on highly subjective interpretations of someone's intent, it just compromises the container.
I'm not sure I agree that inherently compromises it, but go on.
Well, we saw the direct mechanical failure of this flexible approach with the Housing Stability and Tenant Protection Act of 2019, the HSTPA.
Which was, let's be fair, a massive piece of legislation aimed at preventing a homelessness crisis, right? Not creating a squatter loophole.
The intent of the legislation is irrelevant to the mechanical failure it caused, though. Yes, the HSTPA was passed to protect vulnerable renters in a city where over half the population is low income. I acknowledge that.
Right.
But let's look at how the law actually functioned on the ground, because the legislation lacked precise, unyielding exclusionary language that explicitly distinguished between a lawful tenant who, fell on hard times and an unauthorized intruder who just broke a window.
Okay, but
It created a procedural nightmare. It inadvertently formalized a rule where anyone who could prove physical occupancy for just 30 days was granted massive legal protections. It essentially erased the boundary of the container. If you could hide in a house for 30 days, the police could no longer remove you as a trespasser. The rightful owner had to take you to civil housing court. This created an absolute crisis for everyday New York homeowners.
Okay, let me stop you right there. Because your framing of the 30-day rule under the HSTPA actually proves my point, not yours. You are arguing for strict, codified rules.
I am.
The 30-day rule was a highly codified rule. It was a strict, objective boundary. Day 29, you are a trespasser. Day 30, you are a tenant with civil court protections. That is the ultimate checklist. And what happened when the state provided that checklist?
Well, it was exploited.
Exactly. It was exploited ruthlessly by professional tenants who knew exactly how to take that specific statutory box to just paralyze the legal system.
But they were manipulating the lack of a proper boundary.
No, they were using the boundary. They knew that if they could manufacture a fake Amazon delivery receipt with their name and the property address, or, if they could convince a locksmith to change the deadbolt and then show a police officer a fabricated, downloaded lease agreement, they had crossed the codified threshold.
Right.
They met the 30-day standard on paper. Modern New York has tried to fix this with clumsy legislative patches, just layering new rigid rules over the old rigid rules.
But that is exactly why the 2024 state budget changes and NY Bill S2366 were introduced, to correct that specific error by explicitly redefining unauthorized occupants as trespassers, regardless of a 30-day timeline.
But you are just building a new wall for them to climb over. If you want to understand how a system should actually evaluate property rights, you have to abandon the checklist and look at the deeply intellectual frameworks taught at Stern College itself.
Okay, how so?
Let's look at their advanced Talmud courses, specifically Tales 5237, Bava Batra I. This course doesn't just read rules off a page. It profoundly examines the philosophy of property division and the rights of a squatter who makes an ownership claim.
Right, the Talmudic law.
Yes. In Talmudic law, there is a concept called Chiskit Gimil Shanim. It means 3 years of uninterrupted possession.
Which is, I have to point out, a codified timeline. 3 years. It is a strict numerical boundary, just like a 12-8 credit requirement for a degree.
That physical presence for 3 years automatically grants ownership.
No.
No. It rigorously interrogates the claims of the squatter alongside the silence of the previous owner. Why 3 years? Because historically, that was the duration of an agricultural crop cycle, or, the maximum amount of time a person could reasonably be expected to safeguard a physical deed before it was lost or degraded.
Okay.
The court asks questions. Did the original owner protest during those 3 years? Were they in a different province, say, Judea instead of Galilee, making it literally impossible for them to know about the squatter?
Right, establishing context.
Exactly. The Talmud acknowledges that physical presence alone is meaningless without examining the substantive reality, the geographical context, and the psychological intent of the parties involved. Intellectual and legal systems must prioritize this substantive reality. When you rely solely on rigid statutory checklists, you are handing bad actors the very tools they use to legitimize their theft.
I see why you think that, but let me give you a different perspective. We are dealing with the modern architecture of occupancy here.
Meaning what exactly?
Meaning, when we talk about occupancy today, we are fundamentally talking about formal, legally recognized belonging. The Talmudic courts you referenced operated in close-knit communities where everyone knew everyone's business, making intent much easier to verify.
That's a fair point.
Today, we operate in massive, anonymous systems. Let's look at the incredible rigor required by Stern College for its science majors to understand why strict codification of occupancy is non-negotiable.
Wait, how does a science major connect to a squatter breaking into a home?
It connects entirely through the concept of sequential verified legitimacy. Let's say you want a Bachelor of Arts in Biochemistry at Stern. It requires exactly 51 credits.
Right.
This includes heavy, highly supervised laboratory work, like Chem 1377, the Principles of Biochemistry Lab. A physics major also requires 51 credits, culminating in highly specialized, mathematically intense courses like Phys 4621, Quantum Mechanics.
Intense courses, sure.
These are not arbitrary numbers. They represent a codified sequence of mastery. You cannot simply walk into the Stern College Science Building, sit quietly in the back row of the quantum mechanics lecture for 30 days, physically utilize the lab equipment, and then demand a Bachelor of Arts.
Well, obviously not.
Your physical presence in that physical space is completely irrelevant if you have not formally enrolled, if you have not paid tuition, and if you haven't submitted to the codified procedures and prerequisites of the university. You are not a student. You are an unauthorized occupant of that classroom.
But a classroom is not a basic human need like shelter. You can't equate the two.
The mechanism of systemic value is exactly the same, though. The institution recognizes that the degree only retains its societal value if the boundaries of what constitutes an education are explicitly codified and fiercely defended.
I understand the analogy, but
Without those strict mathematical requirements, like the mandate that a student must be in residence full-time in New York for at least 6 semesters, completing 60% of their major physically at Stern, the integrity of the degree collapses.
okay.
The same absolute logic must apply to physical real estate. A person cannot claim property rights simply by changing the locks and successfully hiding in a home. This is why the 2024 New York State budget update was an existential correction.
By stripping the rights.
By explicitly and rigidly stating that squatters are not tenants, it removes the ambiguity of intent. It states that if you lack the formal legal prerequisite of permission, your occupancy is void.
Look, you are relying on formal labels, enrollment, tenancy, prerequisites, as if those labels are perfectly and flawlessly managed by the institutions that create them.
They are the best tools we have.
Are they? Let's look at what actually happens mechanically when a legal system relies too heavily on codified procedural rules to govern occupancy. The rules themselves become the weapon. I want to look at the astonishing case of the Indian American man in East Meadow, Long Island, because it perfectly dismantles your theory that strict procedural rules protect property.
The East Meadow case is a famous example, but I would argue it proves a lack of enforcement, not a failure of the rules themselves.
Let's walk through the actual mechanics of what he did, though. This man managed to live rent-free in a 2,081 square foot, 3-bedroom home for 23 years.
23 years, it's staggering.
The bank foreclosed on him in the year 2000. He lost his legal right to the property. So how did he remain in that physical space until 2023 without ever paying his estimated $2,175 monthly mortgage?
Through bankruptcy filings.
Right. He did it by ruthlessly manipulating one of the most strict, codified rules in the American legal system, the U.S. Bankruptcy Code. Specifically, he exploited Title 11, Section 362, the automatic stay.
For the sake of clarity, let's detail exactly how the automatic stay functions for the listeners.
Go ahead.
When a person files a bankruptcy petition, federal law immediately and automatically halts all collection efforts, foreclosures, and evictions against the debtor. It is a procedural injunction.
Instantaneously.
Yes. The logic is that the federal bankruptcy court needs time to pause everything, assess the debtor's estate, and figure out how to equitably distribute assets to creditors.
Exactly. It is a rigid procedural mechanism designed to create a clean boundary. It is exactly the kind of unyielding rule you advocate for.
Right, but
let's look at the reality. This occupant, along with at least 3 other individuals who conveniently claimed the East Meadow home as their primary address, including one person literally named John Smith, filed for Chapter 13 bankruptcy in the Brooklyn Federal Court over and over again.
just a blatant abuse of the system.
Every time the local state housing court issued an eviction notice, one of the occupants would file a bare-bones bankruptcy petition. The moment the petition was stamped by the clerk, the federal automatic stay triggered. Federal law supersedes state law. The local eviction was instantly frozen.
And then what happened to the petitions?
The bankruptcy court would eventually dismiss the case a few months later because the filer never submitted the required financial follow-up documents. But the moment it was dismissed, the local eviction process had to restart from the beginning.
Because the timeline resets.
Exactly. And when it got close to an actual physical eviction again, another occupant would file a new bankruptcy petition. They did this 7 different times.
And Chase Bank eventually just gave up and sold the distressed property asset to a company called Diamond Ridge.
Yes, Diamond Ridge bought the property and, recognizing how profoundly the codified system was broken, literally offered the occupant $20,000 in cash just to leave voluntarily.
Which is infuriating.
He refused. He chose instead to just file for bankruptcy again in 2019 and again in 2020. My point is this. He fulfilled the technical, procedural requirements of the automatic stay every single time. He checked the codified boxes. He paid the filing fee.
But he was acting in bad faith.
He was completely violating the spirit and intent of the law. When systems rely on statutory checklists, they invite manipulation by bad actors who will happily follow your procedures to steal your property.
Okay, you are pointing to East Meadow as a failure of codification, but I look at that exact same case and see the complete opposite.
How can you possibly see that as a success of the rules?
Because that is a catastrophic failure of judicial enforcement, not the rules themselves. The fact that an individual or a group of individuals using obvious pseudonyms like John Smith could file for bankruptcy 7 times using the exact same property to trigger an automatic stay, that is a failure of the federal court to enforce a hard boundary against bad faith, frivolous filings.
But the mechanism allowed it.
There are mechanisms within bankruptcy law to bar repeat filers for 180 days or to grant creditors relief from the automatic stay. The judges simply failed to enforce them aggressively. That is an argument for tighter, more unyielding rules, not against them.
I disagree.
And this connects directly to the burden of proof and the current weaponization of the courts, which is the mechanical core of why New York real estate is in such a crisis right now.
Well, it is the mechanical core, yes. The procedural burden of proof in New York has essentially turned the bureaucratic legal system into a weapon wielded by the occupant against the rightful owner.
Absolutely.
If we examine the current crisis in New York's housing courts, the statistics reveal a total systemic collapse. The system is currently backlogged with over 150,000 cases.
150,000, that's just paralyzing.
Year period. The property owner is legally mandated to pay the mortgage, the property taxes, the water bill, and the heating costs.
All while the occupant lives there completely for free.
Exactly. And the occupants intentionally stretch out that timeline using municipal codes.
Which is where the real extortion happens.
Precisely. Let's look at the horrific ordeal of Ilona Itzkov. She owned a 3-unit residential home in Brooklyn. For over 5 years, she battled 2 occupants who completely stopped paying rent.
5 years.
They did not use the bankruptcy stay like the East Meadow case. They used the city's own housing maintenance codes against her. How did they stall the eviction for half a decade? By lodging hundreds of false complaints with the Department of Housing Preservation and Development, the HPD.
The HPD mechanism is particularly vulnerable to this kind of manipulation. When a tenant calls 311 and reports a leak or a lack of heat, the city is legally obligated to send an inspector.
Yes, the occupants would pour a bucket of water on the floor right before the inspector arrived, claiming a massive plumbing failure. Or they would intentionally damage a fixture.
Unbelievable.
The inspector records a violation. The court date for the eviction is automatically adjourned for 60 days because the court will not process an eviction on a property with active, unresolved health and safety violations.
So they just keep manufacturing violations?
The occupants forced the NYP to show up at the property at 2 a.m. and then again at 4 a.m. just to officially check if the boiler was turned on. This created a documented police record of quote-unquote harassment by the landlord. Every false complaint resets the clock.
We see the exact same procedural extortion in the case of Quinn Mee.
Quinn Mee spent 5 years fighting professional occupants who understood the intricate details of city housing regulations far better than the property owners did. They systematically manufactured HPD claims, but they added another layer.
The access issue.
Yes. They would report a violation, but when the landlord hired a contractor to fix it, the occupants would physically refuse the contractor entry. The violation remained open. The eviction remained stalled.
And then comes the demand.
Then they demanded extortion payment. This is the cash for keys economy. They demanded between $50,000 and $90,000 in settlement money just to legally vacate the property they were actively destroying.
And we have to acknowledge how state-funded programs inadvertently exacerbate this entire nightmare.
You mean the legal counsel programs?
Yes. The Universal Access to Justice program, it was designed with the noble intent of providing free legal counsel to low-income tenants facing eviction.
Which is a good thing in theory.
In theory, but mechanically, it actively worsens the backlog. When a case is called, if the tenant does not have a lawyer, the judge frequently adjourns the hearing for another month or two, just so the city can assess if the tenant meets the income eligibility requirements for the free counsel.
Right.
Proving the lease is forged has made the legal system completely unworkable.
The burden of proof is just too high.
But the burden of proof is always heavy in a civilized society, right? And that friction is largely by design to prevent hasty, unjust actions. But let's elevate this by looking at how Stern College handles the complex philosophy of proof in its Talmudic curriculum. Specifically, I want to look at TALS 5251, the advanced course on Shavuot 1.
Shavuot deals heavily with oaths, correct?
Yes, it does. Shavuot 1 examines monetary conflict precisely in the absence of conclusive physical evidence. It explores the exact scenario we are seeing in housing court. Two parties with conflicting claims and murky, contradictory documentation.
Okay, so how do they resolve it?
The Talmud deeply explores when a legally binding oath, a shavua, must be taken by a litigant. It differentiates between an oath on a Torah level versus a rabbinic plane. The entire mechanical premise of the course is about how a structured society resolves a dispute when the empirical facts are deadlocked.
Interesting.
It establishes that when physical evidence fails, shifting the burden of proof via a highly formalized, socially and spiritually terrifying oath is a necessary procedural step. It forces a resolution without resorting to violence. You're essentially forcing the individual to formally bind their soul to their claim.
Right. But modern New York housing court does not operate on the fear of divine retribution. A professional squatter has absolutely no problem signing a sworn affidavit that they have a lease, because the penalty for perjury in civil court is almost never enforced.
Which is exactly why New York is attempting to refine its own modern equivalent of the Shavua through strict secular legislation. NY Bill S-2366, proposed by Senator Scarcella Spanton, is an acknowledgement that the civil housing court's burden of proof has failed in clear-cut trespassing cases.
By changing the definition.
Exactly. By explicitly and legally redefining a tenant to completely exclude a person who enters a property without permission, and by amending Penal Law 26-521 to explicitly forbid criminal trespassing with the intent to squat, the bill fundamentally shifts the jurisdiction.
To the police.
Yes, it aims to allow the police to physically remove squatters immediately. No 15-month civil court delay. No HPD adjournments. No special proceeding. This proves that precise, codified legislation can correct judicial overreach and restore the proper burden of proof to where it belongs, the physical reality of the deed.
I'm sorry, but I just don't buy that. Let me tell you why. Your reliance on police intervention sounds clean in theory, but it is a total disaster in practice.
Why? It bypasses the 15-month wait.
You believe that giving a patrol officer the immediate, on-the-spot authority to physically drag people out of homes without due process in civil court is going to solve the problem? But legislation like S-2366 is just a violent Band-Aid over a fundamentally broken framework of how we assess truth, and it opens the door to horrific abuse. Have you seriously considered the mechanics of the Kat Agostini case?
The Agostini case involved a severe family dispute, which makes it an extreme outlier.
It is not an outlier. It is the exact reality of how shared spaces degrade. Kat Agostini inherited a small family house in Jamaica, Queens. She lived on the first floor and attempted to evict her own sister and her sister's boyfriend from the second floor. Her tenants were her own family.
Right.
The situation became so toxic that the occupants poured highly corrosive chemicals down the drain, intentionally destroying the plumbing architecture to the point where raw sanitary waste actually backed up into Kat's own living unit on the first floor.
A clear destruction of property, which should be a police matter.
Yes, but look at what happened when Kat tried to navigate the legal system. The HPD was weaponized against her. She was literally arrested by the police based on false accusations made by the occupants.
That's a tragedy, but
If you enact S2366 and allow police to bypass civil courts to make instant determinations about who is a tenant and who is a squatter, you are going to see lawful occupants and legitimate property owners arrested. Why? Because a manipulative bad actor is perfectly capable of handing a tired police officer a highly convincing fake lease at 2 in the morning, or making a compelling, tearful claim of domestic abuse.
I mean, police deal with fraud all the time.
Police officers are trained in criminal de-escalation. They are not forensic document examiners, and they are certainly not equipped to untangle complex, multi-year family property disputes on a front porch in the dark. This is exactly why they historically say this is a civil matter.
But the civil matter's what's taking 15 months.
If you force them to act as judge and jury under S2366, the bad actors will just manipulate the police instead of the civil judge. This is why I keep returning to the Talmudic approach. You simply cannot skip the rigorous contextual investigation of intent just because the civil court line is currently moving too slowly.
You are framing the Augustini case as a structural inevitability, but I look at it as a tragedy of a deeply broken family exploiting a broken bureaucracy. However, your focus on intent brings us to a really crucial legal mechanism: adverse possession.
Okay, let's talk about adverse possession.
This is perhaps the ultimate test of physical occupancy versus legal right. Under the old common law, adverse possession allowed someone to eventually claim absolute title to a piece of property simply by occupying it openly, notoriously, exclusively, and continuously for a set statutory period.
Right. The logic being that if the original owner abandons the property and allows someone else to maintain it for a decade, the original owner has effectively relinquished their claim.
Precisely. But New York recognized the profound danger in allowing mere physical presence to override legal title. In 2008, the New York State Legislature fundamentally amended the laws governing adverse possession. New York is now one of the very few jurisdictions in the world that explicitly requires good faith.
Explain the mechanics of the good faith requirement for us.
Sure. Under the 2008 amendments, to claim a property through a 10-year continuous occupation, the claimant must prove they had a reasonable, objective basis to believe they actually owned the property in the first place.
Give me an example.
For example, relying on a legally flawed land survey that showed their fence was on their land, when it was actually 2 feet onto their neighbor's land. They must have possessed a claim of right. Compare this strict moral boundary to international standards.
Right. Other countries do it differently.
Radically differently. In France, under certain conditions, you can acquire property after 30 years even if you acted in absolute bad faith, knowing you were stealing it. In Brazil, it can take as little as 5 years in urban areas under their constitutional right to housing. New York drew a hard line, and the courts have applied highly structural, almost geometric logic to this.
Give me an example of this geometric logic.
Let's look at the incredibly complex Hudson Square Hotel case. This case resolved a massive, multi-million-dollar question about air rights. In New York real estate, zoning might allow you to build up to 6 times the square footage of your ground floor footprint. This is your floor area ratio, or FAR.
Right, vertical building rights.
Exactly. The legal question was this: if an adjacent property owner adversely possesses a tiny 1,000-square-foot piece of your ground-level lot by mistakenly building a one-story structure on it over 10 years, do they only get that physical ground, or do they also successfully steal the 6,000 square feet of highly valuable buildable airspace above it?
Airspace they never physically occupied.
Exactly. They only built a one-story shack. But the appellate division, First Department, ruled, yes, they get the air rights too. The court stated it is the encroachment on the land that allows title to pass. And crucially, with title to land come air rights.
Wow.
It is a perfectly structured mathematical deduction. Property is not just dirt, it is a 3-dimensional vector. You own the ground, therefore you own the vector of space directly above it. If you lose the ground, you lose the vector. It is clear, it is codified, and it is entirely predictable.
Predictable? Are you suggesting the 2008 amendments made things simpler?
They made the logic cleaner.
By making good faith a strict requirement, New York actually made adverse possession infinitely harder for the courts to resolve. Because now, The judges can't just look at the physical, empirical facts of the land. They can't just measure the fence line. They are forced to divine the psychological intent of the occupants from a decade ago.
Well,
Let me draw a direct parallel to the intellectual integrity required in Stern College's humanities curriculum to show you exactly how messy determining good faith really is.
How do humanities courses relate to real estate vectors?
Because the humanities are the study of human intent. If you look at the requirements for a history major at Stern, it demands 33 credits, and it includes a mandatory core course called HIS 3001, Ideas of History I.
Okay.
Or look at the English major, which requires ENGL 2000, Textual Methods and Theory. These disciplines are entirely dedicated to the fact that determining original intent, deciphering human text, and evaluating the good faith of historical actors is an incredibly subjective, endlessly debatable enterprise.
I don't think that's the same thing.
It is. By injecting the concept of good faith into real estate law, you are asking a property judge to become a historian and a forensic psychologist.
I disagree. The court is just looking for objective evidence of a reasonable mistake.
But human mistakes are rarely objective. It forces the court to decide if the occupant truly, in their heart of hearts, believed a faulty deed was real, or if they secretly knew it was flawed and were acting in bad faith.
There are ways to prove that. Sure. If a timber company cuts down trees on your land at night to sell the wood, that is obvious bad faith. But what about a homeowner who genuinely misread a highly complex, hand-drawn property survey from 1952? The subjectivity of good faith makes the law incredibly fragile. You cannot codify the human conscience.
Your skepticism regarding the court's ability to determine intent is interesting, but the requirement of good faith is exactly what separates a civilized property system from medieval conquest.
Medieval conquest?
Yes. If you remove the requirement for good faith, as some other countries do, you are simply rewarding the most patient, calculated thief. The fact that discerning intent requires intellectual rigor, the very rigor taught in Stern's textual methods and theory, is a feature of the system, not a bug.
I think it's a massive bug when courts are backlogged for years. We should demand that our courts do the hard, grueling work of separating the honest mistake from the malicious scheme. If we abandon that effort just because it is procedurally difficult, we abandon the moral underpinning of the law entirely.
But we have to acknowledge that the moral underpinning of the law is currently completely failing the most vulnerable people in the system. We cannot debate the mechanics of squatting without presenting the systemic, macroeconomic failures that actually drive it.
Macroeconomics don't justify theft.
Let's look at the data. Between January 2023 and January 2024, homelessness in New York State increased by 53.1%. That is a staggering rate, roughly 4 times the national average.
Right, it's a crisis.
Being exacerbated by tens of thousands of asylum seekers entering a city with mathematically zero available space. We have to look at history to understand how people react to this kind of pressure.
Are you suggesting that squatting is a legitimate form of social protest?
I am suggesting it is a historical reality born of desperation, not just malice. Look at Maggie Wright, who famously squatted in the Lower East Side of Manhattan in the 1980s. She didn't break into a building because she wanted to exploit a landlord for $90,000 in a cash for keys scam.
Her motivations might have been different, but the act...
She did it out of absolute necessity. She was escaping a violent landlord and had nowhere else to safely go. She and dozens of others took over decaying, entirely abandoned city-owned buildings that were doing nothing but collecting rats and structural damage.
They still didn't own them.
They used their own sweat equity to rebuild the plumbing, patch the roofs, and secure the doors. They formed actual communities. Suggesting that the only viable solution to this kind of systemic crisis is stricter criminalization and immediate police removal entirely ignores the root cause. We need flexible, adaptive alternatives.
What kind of alternatives, practically speaking?
Historically, New York utilized the Urban Homesteading Program, the UHP, in the late 1970s and 1980s. This program actually worked with these unauthorized occupants.
Okay.
If the occupants were genuinely improving the physical structure, The UHP granted them up to $10,000 per unit to legally inhabit and bring these vacant city-owned buildings up to code. It transformed trespassers into legal stakeholders.
It was a very specific program for a very specific era.
Compare this kind of systemic flexibility to Stern College's academic structure. You praised Stern earlier for its rigid 128-credit checklist. But Stern isn't just about rigid boundaries. They possess mechanisms for profound flexibility.
You are referring to their interdisciplinary programs.
Yes, Stern offers a shaped major in studio art, which allows students to literally build their own custom academic pathways across different departments. They offer highly interdisciplinary minors like women's studies.
Right.
The academic catalog explicitly states that the women's studies minor grew out of a social movement and draws on many different disciplines across the humanities and sciences to understand complex lives. When a system, whether it is an academic university or a civic municipality, allows people to build customized, non-traditional pathways outside the rigid historical boundaries, the system thrives and adapts to reality.
I acknowledge the absolute value of those alternative pathways. Both the interdisciplinary academic programs and the historical homesteading programs served important functions. But you are entirely missing the crucial structural mechanism of why they worked.
Which is?
They only functioned successfully because they were ultimately governed by strict, overarching, codified rules.
How is a shaped major governed by strict rules? The whole point is that it's flexible.
Let's look closely at the shaped major at Stern. Yes, it is customized by the student, but it is not academic anarchy. The catalog explicitly states that the shaped major must include a strict minimum of 12 courses. It must have a clearly defined central theme, and it absolutely requires formal faculty approval before the student begins.
Well, obviously there's approval.
The Women's Studies minor explicitly requires 15 credits, mandating a specific core course. ENGL 2901, Introduction to Women's Studies, Theory and Practice. These are highly structured, codified containers within which flexibility is permitted.
But the flexibility exists. That's my point.
Yes, but only with permission. The same logic applies to the urban homesteading program you referenced. The UHP was a formal, city-sanctioned, highly regulated bureaucratic program.
It was an alternative framework.
It involved formal applications, city engineering inspections, and strict financial oversight of the grant money. It was the exact opposite of someone breaking into a private citizen's home in the dead of night and claiming it as their own. True compassion for the housing crisis requires society to build actual affordable housing and implement structured, well-funded social programs. It does not mean allowing individuals like Susan Mascavere of Bayside to have her life destroyed.
The Bayside case again highlights the extreme edge of the spectrum.
It highlights the reality of what happens when boundaries fail. Susan Mascavere inherited her mother's home. It was her family's life savings wrapped up in physical equity. That home was completely hijacked by trespassers.
Which is awful, yes.
Blurring the legal lines between an organized city-run urban renewal program in an abandoned municipal building and a professional tenant extorting a small private landlord for $90,000 destroys the entire social contract of property ownership.
But the social contract is already broken. It is broken when a landlord like Ilana Itzkov has to wait 5 agonizing years and lose $100,000 in rent while the city conducts the supposedly structured, quote-unquote, fair process.
The process is failing because of loopholes.
Your reliance on the container assumes the container isn't full of massive structural holes. The professional tenants who exploited the HSTPA 30-day rule weren't breaking the rules. They were following them to the letter. They knew exactly how the bureaucratic machine worked.
So he fixed the machine.
They knew that if they could manufacture a rent receipt or simply refuse an HPD inspector entry to keep a violation open, the entire eviction process would grind to a halt. When you build a massive fortress of highly codified laws, you are just providing a detailed topographical map to the bad actors on how to lay siege to it.
So your solution is to abandon the codified laws entirely? Just let everyone figure it out on the porch?
My solution is exactly what the Talmudic scholars in Baba Batra are debating.
They understood centuries ago that human nature will always inevitably find a way to circumvent a purely literal mechanical reading of the law. You cannot just look at the paperwork. You have to evaluate the soul of the action.
The soul of the action?
Yes. Does this occupant actually believe, through some complex set of circumstances, that they have a right to this space? Or are they maliciously holding the physical space hostage for financial extortion? New York Bill S2366 tries to simplify this massive psychological question by just universally labeling them all as trespassers.
Which is necessary for public order.
But as we saw with the Catagostini case, the reality on the ground with toxic chemicals, false police reports, and deeply feuding families completely defies simple binary categorization.
Look, if we rely entirely on evaluating the subjective soul of the action in every single instance, the legal system collapses under its own philosophical weight. We see the direct result of that approach right now with the 150,000 backlogged cases in housing court.
That backlog is procedural.
Because the judges are desperately trying to evaluate the complex human context of every single dispute. And as a result, it takes 15 months to process an eviction. Meanwhile, the roof caves in, and the small landlord goes bankrupt.
I'm not saying it's perfect.
Objective rules, while occasionally producing an imperfect outcome in an edge case, provide a necessary baseline of security for the other 99% of society. When the 2024 New York State budget legally clarified that a squatter is a person who enters without permission and explicitly stated they are not a tenant, it gave property owners back their fundamental constitutional right to ownership.
And yet, even with that 2024 budget update, the law still allows for complex exceptions if an occupant initially entered the property lawfully, say as a roommate who wasn't on the lease, or as an informal subtenant, and then overstays after the primary tenant leaves.
Well, subletting is a different category entirely.
The ambiguity persists no matter how many laws you pass, because human relationships and living arrangements are inherently ambiguous. You simply cannot legislate away the messy reality of how human beings share space.
You can and you must draw a definitive legal line. If you enter a property with a valid, verifiable lease agreement, you possess tenant protections. If you break a window and climb through it, you do not. It really is that simple. Attempts to philosophically obfuscate that line only serve the exploiters who thrive in the gray areas.
It is never that simple in practice. Consider this scenario. What if you enter a property, sign a lease, and hand over a security deposit with the explicit permission of someone who you honestly thought was the legal owner? But it turns out they were actually a scammer who illegally rented you a foreclosed property they didn't own.
That's fraud.
Aren't you a malicious squatter? Or are you a victim of financial fraud?
You are a victim of fraud, absolutely, and you have legal recourse against the scammer, but you are still not the lawful tenant of that physical property.
So you just get thrown out on the street?
The true legal owner of the deed should not have to forfeit their property rights or wait 15 months in housing court simply because a third party committed a crime against you. This is exactly why the objective, empirical reality of the title must reign supreme over the subjective experience of the occupant.
Well, as we try to synthesize this incredibly dense, multi-layered discussion, let me summarize my core position. Systems that become overly obsessed with rigid rules and statutory checklists inevitably become paralyzed by their own bureaucracy.
That's your view.
We see this vividly and tragically in New York's housing court hell. The very procedures that were meticulously designed to ensure fairness, like the HPD inspections and the Universal Access to Justice program, have been completely hijacked by professional manipulators, leaving 150,000 cases languishing in a 15-month purgatory.
Right.
Whether we are dealing with the 30-day occupancy rule under the HSTPA or the U.S. Bankruptcy Code's automatic stay being abused 7 times on the same property, bad actors will always find the structural loopholes in a codified wall. I argue that true equity requires a deeply nuanced, context-driven, substantive analysis of intent that is championed by the Talmudic traditions Stern College teaches in its advanced textual courses.
And to summarize my structural stance, whether we are protecting the profound intellectual value of a yeshiva university degree or the physical and financial sanctity of a family's home, strict, objective, and legally codified boundaries are our only effective defense against exploitation.
The boundaries are necessary, I admit, but not sufficient.
Stern College requires exactly 128 credits and strict physical residency, because without those mathematical boundaries, the Bachelor of Arts becomes meaningless. Similarly, state legislation like the 2024 Anti-Squatter Amendments and Bill S-2366 are vital precisely because they remove the dangerous ambiguity that bad actors exploit. You cannot protect the vulnerable members of society by making the rules governing their safety entirely subjective.
I think the one area where we definitively and strongly converge today is the clear recognition that the current New York City housing court system is catastrophically failing every single person involved.
Oh, without question.
It is failing the honest, desperate landlords like Susan Masqueray and Ilona Itzkov, and it is equally failing the honest, low-income tenants who actually need the legal protections that are currently being weaponized by professional scammers.
We certainly agree on the reality of the systemic failure. Where we will have to leave our continued disagreement is on the mechanism of the solution. I remain steadfast that the answer lies in stricter, more precise legislative definitions and immediate, police-enforced mechanisms.
And I will keep advocating for a fundamental, complex overhaul of how our legal institutions mediate the intersection of human intent and physical possession.
There is undoubtedly so much more to explore within the intricate nuances of property law, academic philosophy, and the complex human condition that connects them both.
Absolutely. It's an endless debate.
Please remember to like, subscribe, share, and follow us on your preferred platform to ensure you never miss these deep dives into the frameworks that shape our world.
We deeply appreciate you taking the time to join us for this complex discussion.